Well, welcome back to our conference on the Constitution and the world. I'd like to welcome you to what promises to be a very engaging panel discussion exploring the theme of U.S. legal imperialism, ? So there was some upward inflection there. The global projection of U.S. legal norms. Now we have four distinguished and deeply knowledgeable panelists here who will address this theme from a variety of viewpoints and disciplinary approaches. We'll hear international law, political science, and public and foreign policy perspectives in our conversation today. Each of our panelists will give an opening presentation of 12 to 15 minutes. Afterwards, I'll pose some questions to continue the conversation among the panelists, and then we'll leave time at the end to give you a chance to participate and to raise your questions that have been triggered by the presentations or by the theme of the panel. Now, I'm going to introduce all four speakers now in the order in which they will speak. Now, normally when I do this, when I'm moderating a panel or hosting a speaker, I like to give very lavish introductions for the speakers, but because you already have their biographies in the conference pamphlet, I'm not going to do that today. I'm only going to introduce our speakers in an abbreviated fashion. Although my children might enjoy having me read to them, probably for this audience that will be a somewhat less attractive option. Let me emphasize, however, that the relative brevity of my introductions is radically disproportionate to the level of accomplishment and distinction that each of our panelists has achieved in his career. Now, first you're going to hear from Donald Trey Childress III, who's an associate professor at Pepperdine University School of Law. Before joining the Pepperdine faculty in 2008, he was with the international law firm Jones Day in Washington, D.C., where he focused on Supreme Court and appellate litigation. His primary teaching and research interests are in the areas of international civil litigation, comparative law, and ethics. In his relatively brief academic career, he's published numerous scholarly articles, and his edited volume, The Role of Ethics in International Law, is forthcoming with Cambridge University Press. Professor Childress will be followed by John Dehn, and I hope I'm pronouncing it correct, John. Dehn. Okay, so for those of you who are still bitter about Watergate, you can breathe a sigh of relief. Who's a senior fellow at the Center for the Rule of Law at West Point, where he recently completed an extended military tour of duty as assistant professor in the Department of Law. His teaching and research interests include international law, constitutional law, military law, and international humanitarian law. Prior to his 2006 assignment to the faculty at West Point, John served in various capacities as an Army judge advocate, where he worked on such issues as the Abu Ghraib detention abuses. Our third speaker is my Stanford colleague and one-time sort of boss, to the extent we have such things in universities, Steve Krasner, who's the Graham Stewart Professor of International Studies, also Senior Associate Dean for Social Sciences in the School of Humanities and Sciences, Deputy Director of the Freeman Spogli Institute for International Affairs, and a Fellow at the Hoover Institution. Blending his career in academia with public service, he was from 2005 to 2007 Director of the Policy Planning Staff at the U.S. State Department, where he focused on foreign assistance reform as well as activities related to the promotion of good governance and democratic institutions around the world. The scope of Steve's publication record in his areas of scholarly interest, sovereignty, American foreign policy, and the political determinants of international economic relations is exceeded only by its academic and intellectual significance. His 1999 book, Sovereignty, Organized Hypocrisy, and one of the many books he's written or edited, is among the most important contributions to the literature. Our fourth presentation will be by Thomas Farr, who's a visiting associate professor of religion and international affairs at the Edmund Walsh School of Foreign Service, as well as senior fellow at the Berkeley Center for Religion, Peace, and World Affairs at Georgetown University. At the Berkeley Center, he directs the Religious Freedom Project as well as the program on religion and U.S. foreign policy. Dr. Farr is a former U.S. diplomat, having served, among many other capacities, as the State Department's first director of the Office of International Religious Freedom. His writing on issues related to religion and U.S. national interests has appeared in such publications as Foreign Affairs, Foreign Policy, the Harvard Journal of Law and Public Policy, as well as in multiple edited volumes. His book, World of Faith and Freedom, Why International Religious Liberty is Vital to American National Security, was published by Oxford University Press. Now, Trey Childress is going to begin our presentation by touching on the projection of U.S. norms through the Alien Tort Statute or the Alien Tort Claims Act. He will also touch on the interesting and perhaps counterintuitive implication for the projection of U.S. norms that flow from court access doctrines in the United States. And with that, Trey, the podium is yours.
Thanks so much to Professor Weiner for moderating the panel, to Professor McConnell and the Constitutional Law Center here at Stanford, and Nathan Chapman for inviting us all here for what is a lovely day, even by Malibu standards, where I came in from this morning. When I was coming in this morning, there was a forecast for significant Santa Ana winds, which if any of you know who live in California, that means it is fire season in Southern California, and in hope of not encouraging a fire in Southern California, but hopefully lighting a small one here, I thought it would be useful to divide my remarks into three parts. In the first, I want to do some brush clearing, because it's always good during fire season to clean brush. I then want to light what I would consider a controlled blaze by saying something hopefully a little provocative, which will lead to further discussion. And then I want to try to put out the fire and offer some points for further study and thought. Brush clearing. The title of the panel has two words, neither of which I necessarily think is completely appropriate for what we're talking about today. The first word is imperialism, and whether or not American courts are in the business of being imperial actors, imposing their normative view and American substantive law on foreign countries. The second word, which in a way can relate to the first, but is a bit more modest and perhaps more sophisticated, is projection of U.S. norms, which was also in the title. The idea being that U.S. courts project U.S. law, signal U.S. norms abroad in hopes, I think, of encouraging some change in the foreign law that is the subject of the projection. I'm not sure either one of these words is necessarily appropriate for what we see today. In fact, probably what we see most is not imperialism or projection as much as American exceptionalism. If you look historically, the projection of U.S. constitutional norms as they bear out today, I think, has been a radical failure. That doesn't mean there have not been good instances of American constitutional law doctrine that have made their way into foreign law and foreign constitutions. But as a recent empirical study by David Law shows, most countries around the world have in fact rejected the American constitutional framework of a broad system of federalism and separation of powers in favor of a more Canadian rights-based approach to law. So in the constitutional context, I'm not really sure there is much projection, and if there is projection going on, I'm not sure there's much imperialism. And if there's not much imperialism, I'm also not sure there's much transplantation or acceptance of U.S. legal norms, at least when it comes to constitutional law. I'm also not really sure there's that much projection or imperialism when it comes to straight public law or criminal law in the U.S. context. And that's largely because public law and criminal law is largely seen as territorial. There are some limited instances where we seek to apply criminal laws of the United States to foreign conduct, but for the most part, they either involve effects that happen in the United States, which gives a nexus to this country, or they involve a United States citizen under which the assertion of jurisdiction should presumptively be legitimate and legal under international law. Likewise, when things occur abroad, we also have to negotiate through a process of extradition to allow the person to come back into the United States in order for them to stand trial and be subject to a valid and binding judgment. I think then what we're talking about is mostly private law assertions of power by a court, either in the context of the Alien Tort Statute, which is a hybrid statute which incorporates some public law notions into private law adjudication, but more particularly the adjudication, which are in most cases tort claims, international human rights tort claims by American courts, applying either some iteration of international law as viewed through a treaty provision or customary international law, also known as the law of nations, or by applying domestic tort law. There are, for instance, cases filed in state court alleging human rights violations that have occurred abroad that either involve foreign plaintiffs or foreign defendants, and are subject to potentially, and most of these cases do not end up reaching judgment, so we still do not know the mets and bounds of the due process arguments, but potentially subject to United States law. The worry in those circumstances is that a United States court is pronouncing either U.S. law in the domestic tort context or international law in the Alien Tort Statute context on facts or occurrences or omissions or activities that happen abroad. And by virtue of doing that, it is supplanting local remedies, supplanting local law, projecting in an imperial way the law of the United States or the view of international law undertaken by courts in the United States on foreign sovereigns. That leads to a conflict between United States legal principles and foreign legal principles, which complicates international relations and amounts, in the views of some, to the exercise of international relations powers on the parts of the federal courts, and indeed it could be also on the part of state courts abroad. We see this in three areas. Federal law, so we have antitrust statutes, which purport to control activities that happen abroad. We also have securities laws, which purport to control activity that occur abroad. But in both those instances, courts have developed either clear statement rules limiting the extraterritorial application of those laws to facts abroad, or indeed have required some sort of effect or nexus with the United States in order to justify the assertion of jurisdiction, both under U.S. law and also under international law. So the broad idea that we are adjudicating any and every case or controversy that happens anywhere and everywhere in the world without a nexus to the United States is not completely accurate when you actually start to study the cases. Those are cases occurring under federal law. We also have cases occurring under federal common law, and under that guise, because it involves international law, I would probably put the Alien Tort Statute, which is back in the news, both because the United States Supreme Court has made the term this year much more interesting for international law scholars by having a case regarding corporate liability in the Alien Tort Statute context, as well as regarding a liability of non-natural persons in the Torture Victims Protection Act context, and also because in the past 2 days, the United States Court of Appeals for the Ninth Circuit has issued a very short 166-page opinion with fractured reasoning regarding interpretation of the Alien Tort Statute, in a nutshell basically holding that it could be applied to conduct solely occurring abroad between two aliens and as to corporations under at least a purposeful theory of aiding and abetting liability as pled in the complaint. So that's federal common law being used to adjudicate facts, omissions, or occurrences abroad. And then, as I said earlier, there may also be state law. So in many of these ATS cases, there are pendant claims, supplemental claims of violations of state tort law, or indeed in some cases like Doe v. Unical, also filed here in the great state of California. The plaintiffs, besides filing in federal court, also go to file these cases in state court alleging state tort law claims for acts or omissions occurring abroad. All of these may trouble us. All of these may trouble us as examples of American courts using a very long-arm approach, to borrow something from personal jurisdiction, to adjudicate cases which have very little connection to the United States. The fact that there's very little connection, however, is belied by the empirical evidence. And the empirical evidence is actually somewhat surprising. So in the literature, there is a belief that there's been a transnational litigation explosion in the United States based on the basis of forum shopping, favorable procedural rules, favorable substantive law rules under both federal law, federal common law, and state law. Foreign plaintiffs are bringing suit in the United States. The evidence since 1985 going up to 2005 tends to show a decline, actually, in cases filed under alienage jurisdiction in the United States, and cases generally involving foreign parties or plaintiffs in the United States. The most recent evidence from 2005 says there were about 2,000 cases filed in United States Federal District Court which involved a foreign plaintiff or a foreign defendant, which make up about 1% or less than 1% of the entire docket of the United States Federal District Courts. In those cases, they were roughly split evenly between foreign plaintiffs filing cases against domestic defendants, thus making the assertion of personal jurisdiction viable, or foreign plaintiffs suing against foreign defendants, although it was much harder in the alienage context, and that's why they used the Alien Tort Statute, divided equally between foreign, or rather domestic plaintiffs suing foreign plaintiffs. In the context of those cases, so we have about 1,000 cases where there's a foreign plaintiff suing in the United States, about 1,000 cases where there's a domestic plaintiff suing a foreign company or suing about a foreign act in the United States. About half of those are in fact dismissed. Dismissed under grounds of forum nonconveniens, assuming there's an independent and adequate alternative forum, thus forcing the foreign plaintiff in most circumstances, but also in some cases the domestic plaintiff, to go abroad to seek remedy first in the state where the act, omission, occurrence, or injury actually happened. So if the argument is that United States federal courts are generally speaking pronouncing either U.S. law or international law in the guise of federal common law on activities occurring abroad. In fact, that's not the case. Now, if that's explicitly not the case, that we are perhaps not projecting our law on foreign acts, omissions, or transactions through the litigation process, there may actually be some reason to believe that we are implicitly encouraging law reform in other countries by, in fact, dismissing cases and encouraging the filing of those cases elsewhere. So, for instance, America is an outlier when it comes to class action law, and yet the country of Mexico now has implemented class action procedures to allow cases that, generally speaking, have been hard to file in the United States. Now they're allowed to file them in Mexico. Similarly, when cases are dismissed on grounds of forum nonconveniens, many states actually change their underlying substantive law or procedural rules in order to make the foreign forum now more fair to the pleading of the case. So there's some reason to believe, and some of the evidence is anecdotal, and it's now the subject of a larger empirical study, that there have been changes in the forum nonconveniens analysis through which foreign plaintiffs, when cases are dismissed in the United States, actually do go back to their home countries and with lawyers seek legal changes, both in procedure and substantive law, to allow them to file cases that they were prevented from filing in the United States. To wit, there is a projection, although implicit, of U.S. legal norms, both substantive and procedural, in other countries, but not happening through imperialism or overreaching by U.S. courts, but in fact happening because, generally speaking, U.S. courts are closing the doors to foreign cases being filed in the United States. Now, there are, of course, exceptions, and most of the exceptions tend to make very big headlines. For instance, the Surrey v. Rio Tinto decision, which was not dismissed on any of the various constitutional or prudential grounds, such as plausibility, international comedy, or political question. There is also the Kiobel case, which is pending before the United States Supreme Court. So it is not ironclad, in fact, that United States courts are fully getting out of the business of adjudicating cases or harms that occur abroad. But what we can tell, looking not at isolated cases, but looking at the empirical evidence writ large, is that there has been a contraction on the part of foreign plaintiffs in particular coming to the United States and filing cases involving foreign facts. And even in those cases, and even when those cases involve U.S. plaintiffs, the federal courts have continued to contract, encouraging the cases to go forward in the place that has the most logical nexus or connection to the case at bar, which generally speaking is the law of the place of injury, which connects in some ways the underlying law of the place with the action. So again, if the idea is that U.S. law is being used to overreach, that foreign law is being applied to foreign facts, as a matter of the empirical evidence when it comes to conflicts of laws analysis, it actually appears otherwise. That either U.S. courts encourage the filing of cases abroad because those are precisely where those cases should be filed, and to the extent that the choice of law rules determine that the foreign forum is the most appropriate place, or in the limited cases where the case proceeds to trial in the United States, and those would be cases most specifically where domestic plaintiff is suing a domestic corporation for an injury that occurred abroad. The choice of law process generally leads the court not to apply forum, U.S. law, but to apply foreign law to the transaction. Again, there's some empirical questioning about this, but that appears to be the way the recent empirical evidence suggests that, in fact, we don't see the wide application of forum U.S. law to these cases. We, in fact, either see them taken and dismissed and turned into foreign cases, or sent over to, or held in the United States and adjudicated under foreign law through the choice of law process. So after doing brush clearing, hopefully lighting a little bit of a fire by saying, in fact, we don't see imperialism, we do not see projection, but in fact what we see is exceptionalism, and to the extent there is any projection at all, it is implicit and not explicit, encouraging, not mandating, that things happen abroad. I think we actually may be able to define some limiting principles when it comes to cases that involve foreign plaintiffs, foreign defendants, and foreign injuries. And the principles, which I will just list, and if we have time, we can talk about them in discussion, are as follows. Where there is a domestic plaintiff, a domestic defendant, and a foreign injury, and where the case is filed in a United States court, it seems to be appropriate to use the standard principles of the choice of law process to determine what law should be applied, and it would seem to be appropriate to have that case adjudicated in a U.S. court, because both the plaintiff and the defendant are from the United States. Where there is a domestic plaintiff and a foreign defendant, For instance, a foreign corporation involving a foreign injury, both the choice of law process and forum nonconvenience come together and should provide the court with enough evidence to determine which state's law is to be applied, and in the case where it is a foreign state's law to be applied, it might counsel in favor of the court dismissing and encouraging the action to be brought in a foreign state. Where there's a foreign plaintiff, a domestic defendant, and also a foreign injury, the forum nonconvenience and choice of law analysis might be inverted. The court should still seek to determine whether or not U.S. law or some foreign law is to be applied, but in so doing, it should give consideration to the fact that a domestic defendant is involved in the suit. And finally, in the so-called foreign cubed case, where you have a foreign plaintiff, a foreign defendant, and a foreign injury, those would particularly seem to be the types of cases that should be heard in a foreign forum simply because it is the most interested state, either in terms of the choice of law process or in terms of a revised comity analysis, which takes account of the fact that simply the application of U.S. law to a case or controversy does nothing unless there is a remedy, and the remedial powers of the U.S. courts to enforce either damages awards against foreign corporations or to enforce injunctive relief against U.S. or foreign corporations in a foreign court is an incredibly complicated affair that raises a whole host of international comity issues. With that, I'll turn it over to John.
Great, thanks. Before I give the microphone to John, let me just ask a quick taxonomic question.
Sure.
Trey, you described kinds of cases arising under antitrust or securities law as being private litigation, but don't we typically think of those as being sort of public law issues to the extent that they involve the state's regulatory interest? It's just a small taxonomic point.
I think you're right. I mean, I think that what you see in these areas, and I would lump the Alien Tort Statute as well, is that there's a blend of public and private interests. I would classify it as private simply because unless the United States government is suing in the securities context, in a lot of these cases it's private parties, and in all the ATS cases it's private parties, there seems to also be a private function. In other words, the private part of law is being used to serve a public end. So I agree with the taxonomic clarification that in many ways these are public rights, public duties, public laws, public issues, but the fact that they're being brought by private parties and not states, I think, changes the analysis and makes it more rich and interesting for us to consider the way that plays out when you have a conflict between states.
Great, thanks. So you can see, in fact, that Trey is an experienced litigator. Not only did he speak without notes, but he came in right on time. He's used to the red light going on. Now, in his remarks, John Dehn will also consider the ATS, but he'll touch on ways in which international law places constraints on the projection of U.S. legal norms abroad. Drawing on his military law experience, he'll consider how the Military Commissions Act and other U.S. law provisions provide a somewhat different way of thinking about how international law might affect our views of the proper extraterritorial application of U.S. law. John?
Thank you very much, and thank you to everyone for the invitation to speak today. I largely agree with Trey, but I have some points of disagreement about whether we're really talking about a private lawsuit or a lawsuit between private individuals. I think, given the historical origins of the law of nations, I think the public interests have to be are present, must be present, in order to confer jurisdiction on federal courts, and that those kind of rule the day on the way rules work under the Alien Tort Statute. I do want to say, though, that I don't really have time, as I put my notes together and wanted to explain kind of the conceptual historical origins of international law constraints on the projection of U.S. law. I don't have time to discuss the Military Commissions Act of 2009 in any great detail, although I will say that my view of the ATS is heavily influenced by my work on the extraterritorial application of war crimes. And arguments about whether crimes within the Military Commissions Act are war crimes as defined by international law, subject to the principle of universal jurisdiction, or whether there are other violations of international humanitarian law that do not, to which the principle of universal jurisdiction does not attach, and therefore they're not international war crimes, and their assertion is a violation of the nullum crimen principle in international law, known as ex post facto in U.S. domestic law. So I'm going to use this time to talk about the origins of prescriptive jurisdiction and then how it actually influences the extraterritorial application of the ATS. But the first point I want to make kind of exemplifies the difficulties that Trey, if you're not a conflict of laws person, that Trey's remarks generated for you. The conflict of laws is equally despised by lawyers and law students because it's very difficult. And so I've attempted to simplify my remarks to make it more clear, but only you can judge whether I have done that successfully. And the first point I want to make exemplifies the point I just made. We have to start with the understanding that within the U.S. domestic legal system, any limits international law might place on the projection of U.S. norms are interpretive limits, not legal ones. What I mean by that is under the Supreme Court's decision in the Charming Betsy, or Murray against the schooner Charming Betsy, the court said that an act of Congress ought never to be construed or interpreted to violate the law of nations unless no other construction remains. Two things are implicit. One is explicit and one is implicit. One, explicitly, we're going to interpret acts of Congress to comply with international law. Implicitly, we're saying that Congress possesses the power, when there's no way to reconcile domestic and international law, to violate international law. And other cases, such as the later in time rule, that discuss the later in time rule, as discussed on the last panel, make clear Congress's constitutional power to violate international law as a matter of national policy. So when I say that international law might place constraints on the projection of U.S. norms, I mean that only in the sense that the way that we interpret statutes that are not clear on that topic. So let me propose how international law governing nations' prescriptive or lawmaking jurisdiction should affect our interpretation of the Alien Tort Statute. I want to make 2 points. First, that the civil remedy permitted by the Alien Tort Statute is solely U.S. federal law, and that in the absence of a clear intent to the contrary, its extraterritorial application is necessarily understood by reference to international law delimiting a state's power to make law. In this context, the applicable principles are the territoriality and nationality, but not, for reasons I will explain, the universality principle often asserted by courts and commentators. And second, I want to point out that defining the remedial right, particularly in the original ATS era, requires a domestic law defining those who might be sued as tortfeasors. Given the lack of domestic law developed under the ATS, there's a natural desire to look to international law in deciding who might be sued. And in the case of the ATS, they often look to international criminal law. But this is an ill-advised result of failing to observe the first principle, or the first point I want to make, that it is domestic law asserted extraterritorially and therefore is subject to these international law, legal constraints by interpretation. So when the first Judiciary Act included the original ATS, the law of nations primarily consisted of the application of the law of nature to nations with certain specific alterations occasioned by treaties or the customs of civilized nations. Being based in the natural law, the fundamental principles of perfect equality and perfect independence of nations were paramount. Civilized nations were free to enjoy their liberty without interference by other nations or men, so long as they did not infringe the rights of others or submit to their authority. Interference with the rights of other nations included infringing the rights of ambassadors or consuls, violating pledges of safe conduct to its citizens, or making private war against nations through acts of piracy. It also included when nationals of one state intentionally injured the nationals of another state at a time when their two nations were at peace. Any of those things violated these natural law principles. The law of nations was thought to be equally binding on the nation as a whole and all of its components, meaning not only was the state as an abstract entity bound, but also its governments, its organs, and its citizens. Violations perpetrated by individuals required nations to punish the perpetrator, extradite them to face punishment when appropriate, or provide some other remedy for the injury suffered. This is true in both the war crimes context and in civil law implementing the law of nations. If a nation failed to do these things, it was believed to have ratified and become responsible to the injured state for the violation and potentially faced reprisals or war. Thus, the ATS was but one way that the first Congress attempted to implement the United States international law obligations, as was discussed in the first panel. Because state courts had proven unreliable forums for protecting the rights of aliens under the law of nations and treaties of the United States, such as the Jay Treaty, earlier discussed, providing access to federal district courts provided a forum that better appreciated the national risks inherent in such cases. requirement to respect sovereignty of other nations also substantially delimits the power of nations to extend the authority of their laws to activities outside their borders. The presumption against extraterritorial application of U.S. laws is undoubtedly in part a creature of this aspect of the law of nations, and the presumption was particularly strong with regard to criminal laws. Criminal laws of the original ATS era were understood to apply only territorially, or to a nation's public or private vessels at sea, or flagged vessels at sea, or to public vessels in foreign ports. Otherwise, if the nation tried to extend its laws to say the high seas outside the context of piracy, where pirates were acting outside the context of the entire law of nations, it would be infringing the right of other nations to freely use the high seas. Jurisdiction over civil cases or claims, particularly in admiralty, were more permissive, but at the very least would not have permitted the extension of a nation's domestic laws to foreign territories. So to do so would imply a lack of equality between states and interfere with a foreign nation's perfect freedom and independence. Because the law of nations only dealt with rights, duties, and remedies between states, its application in cases involving individuals was understood to require incorporation by legislation, or in the common law legal systems, one might say judicial creation, of domestic law. Both Blackstone's and Vattel's commentary clearly make the point that once the law of nations is adapted to cases involving individuals, it becomes domestic law. The Alien Tort Statute must therefore be understood, as it was by the Supreme Court in Sosa and by many courts and scholars since, to have permitted the creation of a domestic federal civil remedy for a violation of the law of nations. And in the Ninth Circuit, they recently reached just that conclusion, that such cases arise under federal law and therefore are within Article 3's grant of jurisdiction. But then they said because they involve international matters, they can be extended extraterritorially without concern. That is not the way prescriptive jurisdiction worked, as I just explained. Legislatively creating or allowing the judicial creation of a civil remedy is an act of lawmaking, an exercise of a nation's prescriptive powers. Violations of the law of nations were not, strictly speaking, transitory actions, which are private claims that follow individuals wherever they are and can be adjudicated in courts that have jurisdiction over the individuals. The necessary requirement for an infringement of a right or a breach of duty owed between or among nations localized the issue in a functional rather than a territorial way by making it one of sovereign responsibility. This is why I say it's not purely an issue of private law. There is a necessary public component that attaches to ATS cases. Therefore, under the Charming Betsy canon, the U.S. federal law and the ATS that allows federal courts to make it should be interpreted as and applied without clear congressional intent to the contrary in a manner consistent with relevant international law, including the law governing prescriptive jurisdiction. Now, I don't have time to go through all the types of prescriptive jurisdiction. I'm only going to talk about the ones that apply here, which happen to be the exact opposite of the ones that apply in the context of extraterritorial war crimes, because the objects are different. One is a suit by an alien, and one is a suit by the United States against an alien. So the other principles that I'm going to pass discussion off unless we discuss the Military Commissions Act are clearly inapplicable in this context. Some of these principles are broader than those that existed in the late 18th and early 19th century as well, for reasons that there isn't adequate time to discuss now, but I anticipate Steve's remarks about how the process of norm internalization works in the international system to be highly relevant to that topic. Territoriality, unsurprisingly, refers to a state's power to legislate and govern within its borders. From what I earlier said about the law of nature, it should be obvious that this principle is fundamental to the international system. The law of nations or treaty violation against an alien within the U.S. could implicate this principle. Of course, other potentially applicable federal law might limit the extent to which relief is available. All other principles, when exercised in another state's territory, are exceptions to the territorial principle. Okay? So we have to view other international law permitting the extraterritorial application of domestic law to be an exception to that very fundamental territorial principle. This is what it means when people are concerned that the ATS is infringing on the sovereignty of other nations. Nationality refers to a nation's power to prescribe law applicable to its nationals wherever they are. We have all probably heard of sex tourism and other laws that apply to Americans wherever they travel, even foreign countries. That wouldn't have happened in the original ATS era. But allowing states this power enables them to vindicate legitimate concerns about, and sometimes to vindicate their responsibilities for, the conduct of their nationals abroad. Providing a federal remedy against U.S. citizens violating the law of nations abroad would be consistent with this principle. The universality principle allows nations to adjudicate certain violations of international law without regard to the location of the act or the nationality of the perpetrator or victim. Now, we say adjudicate, but that doesn't necessarily mean enforce, including extradition or arrest. Those things are governed by other principles of international law. To this point, the universality principle has only evolved to the point of allowing criminal punishment of genocide, certain serious violations of the laws of war, piracy, and crimes against humanity. It is often thought of only in adjudicatory terms, meaning it is thought to empower a nation to adjudicate these crimes. However, it also has a prescriptive element. A state must necessarily prescribe and the underlying conduct as a crime in its domestic law in order to impose punishment. The problem with applying the universality principle in the ATS context is that it is not currently and never has permitted the creation of a civil remedy. It empowered individual states to vindicate the interests of the international community in preventing these acts by punishing them, not by compensating victims. Again, the purpose of universality is public law, is to vindicate public interests in public law, not private interests in private law. Now, similar considerations to those that underlie universal criminal jurisdiction may ultimately lead states to expand the universality principle to encompass civil remedies, but this is not now the law. Therefore, the universality principle does not provide the necessary exception to the general principle of territoriality in this context. And in this area is where you see academics in the common law and civil law traditions, raised in the common law and civil law traditions, talk past one another. It also happens in the war crimes context. It's okay to argue by analogy in the common law system. The court is not necessarily bound to the written law. But in a civil law system, they admit the existence of customary international law, but only after somebody writes it down. It's got to be in a treaty, and then we can argue that the rules we like in the treaty are international or customary international law. And if they really like the rules in the treaty, we can argue that they're jus cogens. But it seems, in my exchanges across the ocean with my European colleagues, that we really have a problem, or they would have a problem extending the concept of universal jurisdiction to civil remedies for the reasons I mentioned, but also because they're necessarily, by their legal tradition, bound to the law that exists. They're not creating law in the courts. If we think about the application of these principles in relation to the function and purposes of law, I think it all makes sense. Law is a means of governance, and this is what fundamentally underlies conflict of laws analysis. It prescribes rules for human behavior and sets the consequences for their violation. This allows us to understand the consequences of our actions and conform our behavior to what is expected. The rule of law depends as much upon its principled enforcement as it does voluntary compliance with its requirements. The extraterritorial application of uniquely national law to aliens undermines the rule of law. It does not advance it. Why? Because it violates a commonly accepted principle in their effort to enforce a different principle. It also doesn't encourage compliance with the law because there's no notice of which rules apply. And this is fundamentally where we're sitting with corporate liability under the Alien Tort Statute. Because there's no federal common law defining corporations as subject to liability, the natural tendency is to reach to customary international law. Let's look at what customary international law says about the issue of corporate liability. But customary law is underdeveloped. It's still evolving in this area. It doesn't reach these issues yet. It's just gotten about 80 years ago or 70 years ago from the nation state to the individual. It's going to take it a little more time to get to, and it's just now working on, they're just now working on draft articles with regard to international organizations or supranational organizations. So it's going to take time before the law of nations develops to the point of accepting this law. And so there have been some, Ingrid Wirth at Vanderbilt's one, that say we should consider all of these issues federal law, but they then avoid conversation about what that means about prescriptive limits on the extraterritorial application of that domestic law. This is what those prescriptive limits would require. Either that the nationality of the tortfeasor be a U.S. national, or that the tort occur within the territorial United States.
John, thank you very much. I now turn the floor to Steve Krasner, who will add a political science perspective to our conversation and will explore the role of power, bargaining, and persuasion in projecting norms extraterritorially. He'll also touch on the implications of these ideas for using foreign assistance programs to promote U.S. goals, including rule of law programs in particular. Steve?
Thank you. Do I need the clicker or you have the clicker? We can just go to the first slide. So this is basically to prove that I'm a social scientist and not a lawyer, or maybe even just to make me feel more comfortable, since listening to legal discourse for 15 or 20 minutes make you feel what? Somewhat insecure, I suppose I would say. So I thought what I try to do is, give some, not to make an argument, but give some context to what we're thinking about when we're thinking about the U.S. projection of American laws and legal norms. And I think the right place to start is to make a distinction between two things that are going on. One is a situation in which you have American laws which cast a shadow of hierarchy overseas. The shadow of hierarchy can just reflect power, or it may also have some normative weight. That's not clear. But these are situations when you have American laws, Foreign Corrupt Practices Act, some of the provisions of Dodd-Frank about what American corporations have to make public in terms of the overseas payments by natural resources companies to foreign governments. So there's situations in which we pass an American law which governs the behavior of Americans and maybe others in foreign environments. The second is a situation which I think is far more demanding, in which we're actually trying to change domestic authority structures in other countries. All right, so we basically have these two different things that are going on when we think about what the United States is doing when it's trying to project its own legal norms. All right, here are the ways in which a projection can take place. And I think this is actually pretty much an exhaustive, maybe exhausting taxonomy of what's possible. All right, so one way in which countries attempt to alter the behavior of others, or this is something that isn't just something that could refer to states, is persuasion. And it's always good for social scientists to sit and listen to lawyers, because the way in which lawyers reason is so radically different than the way in which social scientists reason. And I think it's so radically different because mostly what lawyers do is persuasion. There's an effort to take a set of logical relationships among a set of claims that are made and to actually try to reason your way through them. It's not about power. It's not about bargaining. It's about trying to persuade another party that your position is correct. And if you're looking at, I think, efforts at persuasion when we're thinking about the projection of U.S. legal norms, I think there are two ways in which persuasion takes place. One is we try to make arguments about people's strategies, preferences over different strategies. So we grant the outcomes that people want to achieve, and we say, look, you're doing it in this way, but you'd be better off if you did it in another way. This legal structure would be better than that legal structure if you want to have faster economic growth. I think persuasion in that sense sometimes works, especially can work if it has some evidence backing it up, although the evidence by no means means automatically that it will be accepted. If you look at efforts to persuade people about what outcomes they should prefer, that I think is way, way more difficult. So you're trying to change their basic preference structure over outcomes as opposed to changing their preference structure over strategies. That's far more difficult, and I think it's hard to find cases where persuasion over basic preferences actually is effective. All right, secondly, bargaining. So if you look at the political science, and I would say social science literature in general, about how international regimes have developed, it is all about bargaining and about resolving market failure problems. And the basic argument here is that if you look at the international environment, it's filled with market failure problems, prisoner's dilemma problems, moral hazard problems, information imperfection problems, and we establish international regimes, including international treaties, international organizations, to resolve those market failure problems. The bargains are all Pareto improving, otherwise it wouldn't be a bargaining problem. The bargains are also self-enforcing because everybody's better off as a result of them, and none of the parties to the bargain have a better alternative outcome. That's the political science literature over the last 20 years. Now, I have to say, nothing that I heard in the kind of four speakers, even though I actually really agree with the conclusions of the speakers, has anything to do with bargaining. And in this sense, I think a lot of legal reasoning doesn't have to do with bargaining. It has to do with sets of principles that you're trying to resolve. All right, finally, so can bargaining work in the international environment? Yes. Does bargaining have much to do with the projection of American legal norms, either in the sense of casting a shadow of hierarchy or actually attempting to alter domestic authority structures in other places? I don't think so in the American case. I mean, the prime example here in the international environment of bargaining, which really did change domestic authority structures, is the expansion of the European Union, where you have thousands, tens of thousands of pages of acquis, which countries that want to join the European Union have to enact into their own national law. Now, you have to say parenthetically what the consequences of that enactment are for actual behavior is a little more problematic, like maybe 30% for Romania and 95% for Sweden. But nevertheless, this is a situation where domestic authority structures are radically changed as a result of a bargaining process. All right, finally, power. And this little 2x2 table that I have here is taken, lifted entirely from an article by Barnett and Duval, which appeared in International Organization in 2005, which I found very valuable in terms of expanding the way in which we normally think about power. So they distinguish two things in the way in which they're analyzing power. One is whether the influence of power is direct or diffuse, and the second is whether interactions take place through specific actors, which is the way in which political scientists and economists usually think about the exercise of power. And the third is and the second way in which it can take place is what they call social relations of constitution. So let me run through these four different possibilities and then conclude by saying a few words about which of these might apply if we're thinking about the projection of American legal norms. All right, one is the one that we're most familiar with, which is compulsory power. Compulsory power basically is you go and you hammer someone over the head in a war, for instance, or it may also be a situation where you have a bargaining structure in which the first mover can take the status quo off the table and say to the other players, look, guys, you can sign a bargain. The bargain's actually not as good as the situation you had in the status quo, but the status quo for you is gone. I think the classic example of that recently in the international environment is the creation of the WTO. It's clear that developing countries would have preferred to just stay with the GATT, where they could have opted in or out of various treaties. In the WTO, they had to sign up for everything. Everything was a lot, including things like intellectual property rights, which have somewhat unraveled, and the GATT's General Agreement on Trade and Services, which they would have preferred not to sign up to. But the industrialized countries gave them no choice. So that's also, I would say, an example of compulsory power or an example of institutional power in which more powerful states can go in and create an environment. And even though it looks like a voluntary agreement, which weaker states don't have, weaker states end up in a situation where they are worse off than they were in the status quo ante. All right, this argument about social relations of constitution, that's a little more complicated. And there are, though, I think, very dramatic examples of this, including dramatic examples that have to do with the law in the international environment. It's what Barnett and Duval call structural power. If you look at the exercise of extraterritorial jurisdiction in the 19th century, The basic reasoning by the European states was these states in the developing world or outside of Europe were not civilized states. They weren't able to actually have legal structure which resembled positive law. And as a result of that, the Europeans and the Americans and the Japanese, to a lesser extent, had a right to set up extraterritorial courts in the Ottoman Empire, in Japan, in China are the most dramatic examples. Only when these countries actually adopted a set of positive laws with a set of modern legal codes were the European powers willing to say that they did not need these extraterritorial courts. That happened first in Japan and then later in other parts of the developing world. But if you look not only at thinking about notions of extraterritorial courts, but at the whole notion of sovereignty in the development of sovereignty in the 19th century, the beginning of the 19th century in the Sino-centric world in China, you have a notion of international order which is totally different than these notions that existed in the West. You have basically a notion of hierarchy. There is no notion of political entities having equality. There's no notions of embassies and ambassadors which have equal rights. There's none of this natural law conception which existed in Europe. By the end of the 19th century, the beginning of the 20th century, that's basically gone. The Chinese have embraced notions of sovereignty. The Japanese even earlier embraced these notions of sovereignty. And you have a situation in which the basic constitutional structure of these polities is radically altered as a result of the superior power of the West. All right, finally, you have these arguments about productive power. And the basic arguments here, I think the best examples here, are situations in which you have kind of ways of doing things, norms of behavior which exist in the more advanced societies of the world, and which then get picked up and copied by weaker entities. So in some ways, it's a little weaker, I have to say, a little weaker notion of the way in which power is projected. I think the most graphic examples of this come from the work of John Meyer, who's in the sociology department at Stanford, in which he and his students have looked at global practices around the world. Everybody has a navy, even countries with no coastline. Maybe not Afghanistan, but Bolivia, yes. But they're hoping to get a coastline, I know. Everybody has a National Science Foundation, even countries with no scientists. So why does that happen? Because Cameroon becomes independent in 1960. They want to be a modern state. They don't exactly know what that means. They go to UNESCO, where UNESCO sends a delegation and says, gee, if you want to be a modern state, you have to have a National Science Foundation, because that's what modern states have. And they create one, even though there are no scientists in the Cameroons. So you have a projection of a set of norms which developed in the industrialized world, which then get projected onto weaker states. All right, so I think the question then is, if we're thinking about the projection of U.S. legal norms, in which of these categories might they work? All right, I think persuasion might work if you're thinking about preferences over strategies, but I don't think it works if you're thinking about preferences over outcomes. I'm not sure in the examples that we were talking about on the panel that there are actually bargaining examples. Bargaining is the most effective way to do this. I don't know if it actually works in the American context. If you're thinking about power, and what's clear is that you need quite big asymmetries of power and resources if you want to go across the first row there. So if you want to think about interactions between specific actors to get the WTO in place or actually conquer someone in war, you need a lot of resources. And you can certainly see in Iraq and Afghanistan where we've devoted very substantial resources. There are not going to be enough resources to get the legal codes that we want in those countries, not even close. If you ask questions about social relations of constitution, I think they're very tricky. I mean, I think in the productive area, some of these things work, but maybe in places where they don't really matter that much. And if you're thinking about structural power, that also, I think, requires very big asymmetries of power, maybe bigger than even the United States or even the West in general has in the contemporary environment. So what I would say is you do see efforts by the United States to project its legal norms overseas. I think those efforts can work to some extent if you're looking at the shadow of hierarchy. Foreign Corrupt Practices Act and other ways in which you have anti-corruption legislation, which is really enforced in other countries by legislation that's been passed in Europe and the United States and other places, I think that can be consequential. If you're thinking about this more ambitious project of changing domestic authority structures in other places, well, I'm not sure it's, well, I shouldn't say, I think it's basically in the contemporary environment likely to be a fool's errand. Because I think the conditions that might make that work, which are very high asymmetries of power or potential bargaining strategies with other countries, I don't think exist in very many places in the contemporary environment.
Thanks, Steve. It wanted to join the WTO, right? This was an asymmetry of power, and the benefits of participating in the regime, even though it wasn't all they wanted, outweighed the costs. Why is one a bargaining and why a power?
Right. So I think this is a clear distinction analytically. So if you look at the WTO situation, Ghana would have been better off without the WTO, period. They would have been better off just with GATT. I mean, under GATT, they just had to sign the trade agreements, and there were a lot of exceptions for developing countries, and they didn't have to sign all of these other agreements. In the WTO regime, they had to sign everything. So they were up here in the pre-WTO world, in GATT. They end up being down here if you just take that away and only leave the WTO and they don't sign up to it. But if they sign up to the WTO, they don't get back to where they were in 1994. I would say if you look at the situation of the countries that are entering the EU, it's true that the benefits are asymmetrical. That is, you look at that bargaining space within the Pareto frontier, you can see deals that would have made them much better off. Like maybe they wanted immediate kind of freedom of movement, and they didn't get it. But they were still better off than they were before they signed up. So I think the distinction is whether or not the more powerful actor can actually take the status quo ante off the table in a way that leaves other actors worse off, and they don't get back to where they were even though they signed the agreement, and it looks like a voluntary agreement.
Great. We'll now hear from Tom Farr, who, like Steve, has cautioned us that he is not a lawyer. His remarks will focus on the projection abroad of U.S. norms regarding religious freedom, including some of the constitutional and policy considerations.
Well, thank you, Alan. It's true, I'm not a lawyer.
There's nothing wrong with it.
I'm actually proud of it. I'm trained as an American diplomat, however, and that means, of course, that I can speak at great length about many things, including things that I know absolutely nothing about. Not peculiar to American diplomacy only, I would add. I do know something about religion and American foreign policy, and in particular the American policy of advancing international religious freedom. And I'd like to give you my views on what the Constitution says with respect to that policy, but I can't do so as a legal scholar. I was encouraged by Alan's evocation of Watergate, and so I'll recall the story of Senator Sam Ervin, who, when challenged about his interpretation of the Constitution and asked, "How do you know that?" Said, "Because I can read the English language, it's my mother tongue." So we'll see if that suffices. Let me give you my argument in a nutshell. The projection of U.S. religious freedom norms in American foreign policy is entirely constitutional and, subject to a few important conditions, is a very good idea. It's a good idea because, as I see it, the norms are transportable. If U.S. diplomacy could facilitate their acceptance beyond American shores, it would help address a global crisis in religious persecution and help advance America's vital interests in the world, including its national security. Now, I'm aware that some legal scholars appear to believe that the Establishment Clause either constrains or prohibits U.S. actions abroad if those actions constitute direct support to particular religious actors or ideas, or even to religion in general. Further, and perhaps even more importantly, there is a broad sense among U.S. diplomatic officials that supporting religion in foreign affairs is unconstitutional or otherwise illegitimate. Such views, as I see it, represent a misreading of the Constitution and hamstring our foreign policy in its fundamental mission, which is to advance American interests in the world. I do not read the Establishment Clause as restricting the U.S. government in its decisions regarding engagement with foreign religious actors or their ideas. any more than the Constitution constrained U.S. foreign policy in its ideological battle with Soviet communism. As I understand it, the Establishment Clause was written to prohibit a national establishment of religion in the United States. Neither its authors nor those who ratified the First Amendment intended it to constrain American foreign policy. At the same time, I believe the norm represented by the Establishment Clause is applicable beyond our shores. It was designed to facilitate the free exercise of religion by preventing its control, manipulation, and corruption by the federal government. A ban on a national establishment of religion, in other words, was intended to constrain government and to free private religious actors to worship as their consciences dictated and to engage in public life on the basis of their religious beliefs. Such a principle is one that can buttress any democracy, in my view, especially one in a highly religious society. Of course, projecting U.S. norms has not been and is unlikely ever to be easy or simple. There are many obstacles to such a project, including the constitutional scruples of U.S. officials, confusion over the content of U.S. norms, and suspicion, both here and abroad, that the advancement of U.S. norms constitutes cultural imperialism. Given these and other problems, I would concede that in some cases and in some countries, the level of difficulty may be so significant that prudence counsels very limited action or no action at all, at least temporarily. For example, our room for projecting U.S. norms in Iran, Saudi Arabia, and China is quite limited at the moment. However, I believe narrow opportunities exist even now in all three of those countries, and should any of them become open to political reform, which is not inconceivable, the development of a liberal religion-state balance will be a major issue. The United States should be prepared to have an impact when that day comes. But when that day has already come, that is, in societies that are now struggling to develop democratic institutions and habits, we should be attempting to persuade them that democracy cannot succeed without religious freedom. Okay, let's sketch in a few details of this argument by addressing briefly three broad questions. First, why would we seek to project U.S. norms of religious freedom in the first place? Second, what are the norms we should advance? And third, how might we accomplish that goal? Since 1998, the United States has been required by law to promote international religious freedom. The International Religious Freedom Act of that year established an office in the State Department headed by an ambassador at large for international religious freedom. The ambassador is authorized to represent the United States in bilateral and multilateral diplomacy, to issue an annual report, and to issue an annual listing of the worst violators of religious freedom against whom sanctions might be applied. He's also authorized to employ foreign aid, democracy and governance funding, and other means to advance religious freedom. Now, I believe there are at least two good reasons for this policy. The first is broadly humanitarian in nature. Two recent reports by the nonpartisan Pew Research Center in Washington conclude that, now listen to this, 70% of the world's population lives in countries in which their religious freedom is either highly or very highly restricted. And the problem is getting worse. While some of this amounts to mere discrimination, that is, some serious disability because of religion, tens of millions of human beings are subject to violent religious persecution because of their beliefs or those of their tormentors. The worst hit, of course, are religious minorities, such as the Copts of Egypt, the Christians of Iraq, the Tibetan Buddhists of China. But majority religious communities are affected as well. For example, anti-blasphemy laws and practices in places like Egypt, Pakistan, and Afghanistan target Sunni Muslim reformers. Recently, an Afghan journalist was sentenced to death because he publicly argued that the Quran supports equality between men and women. Just this year, 2011, two senior Pakistani officials, one a Christian, one a Muslim, were murdered for opposing Pakistan's anti-blasphemy laws. Polls show broad support for the laws and for the murderers. Now, the problem represented in such practices and attitudes, which are widespread in Muslim-majority countries, is substantial. They feed vicious religious persecution and constitute a substantial barrier to the success of democracy. Anti-blasphemy laws harm minorities, but they also deter the voices of Muslim reform, precisely those voices that can help democracy to root. Moreover, the core idea behind these attitudes nourishes violent extremism and terrorism. It is the idea that the defense of Islam warrants the prosecution or murder of anyone who offends Islam. So this leads to the second good reason for advancing U.S. international religious freedom norms, American national security. The last half-century has witnessed a global resurgence of public religion in which religious actors and ideas are having a major impact on society and politics, for better and for worse. This has broad implications for U.S. foreign policy, but it's of particular salience in the lands of Islam. As tyrants are overthrown, Islamic groups and ideas will very likely play a part in what replaces them. In recent months, we've seen this dynamic at work in Egypt, Algeria, Yemen, and most recently in Libya, where the first utterances of the new regime were that Libya will be based on Sharia law. In Egypt, the Muslim Brotherhood will clearly be part of any transition to democracy. Where Muslim-majority nations are seeking democracy, it's in America's vital interest to help democracy take root, especially in those nations that have been incubators of or safe harbors for Islamist terrorism. That is, countries such as Egypt, Pakistan, Iraq, and Afghanistan. A key factor that will determine the success or failure of democracy in these countries is whether Islamic groups will be illiberal and theocratic or liberal and democratic. Will they accept the limits of democracy, including religious freedom? This is a critical question because both history and contemporary studies in social science indicate that religious freedom plays a critical role in accommodating religious doctrine to democratic norms. Indeed, the combined weight of this scholarship suggests that religious freedom is a linchpin of the bundled commodity of fundamental freedoms that make democracy stable and lasting. Other freedoms, such as free expression and freedom of assembly, are also necessary. But religious freedom in its public aspects is often the missing dimension of democracy in these countries. That is a major reason why it bears emphasis in our foreign policy. Advancing religious freedom is also in our interest because it can help counter religion-related terrorism. We should have learned by now that Middle Eastern authoritarianism has encouraged terrorism, not prevented it. The stability we've imputed to authoritarian rulers such as Egypt's Mubarak or Syria's Assad has proven illusory. The illusion of authoritarian stability is unfortunately a temptation that remains strong in American diplomacy. The United States has historically supported Middle Eastern despots, in part because we believe them capable of keeping the lid on Islamist terrorism. But we've been terribly wrong. Violent Islamist extremism, including al-Qaeda, developed in these areas for several reasons. One of them is that autocrats such as Mubarak and the Saudi monarchy have operated by controlling and manipulating religion, ensuring that there was little or no opportunity for the development of liberal Islamic political theologies that might counter Islamist extremism. To sum up, religious freedom can play a role in rooting democracy and countering terrorism. I believe that universal practical norms of religious freedom are embedded in the American system and can usefully be projected abroad. However, those norms are today under serious challenge in the West and in the United States, and this, of course, complicates the project that I have outlined. Let me turn to some brief thoughts on that subject. U.S. norms are best expressed, in my view, by the concept of religious freedom in full, by which I mean full equality under the law for all religious actors and ideas in the private and the public spheres of democratic life, and on a basis no less favorable than that of non-religious actors and their ideas. This formulation raises some problems. It suggests, for example, that religious liberty stands on its own and is not derived from a broader freedom of conscience that includes other sincerely held beliefs. It suggests that religious freedom is not a subset of a broader right to privacy, as argued, for example, by Ronald Dworkin or Lawrence Tribe. My definition also suggests that, whatever its derivation, religious freedom is not merely a private right with no legitimate application in political life. Such a view is highly developed in Europe. It has resulted from historical movements such as French Jacobinism and from contemporary developments such as the determination of European elites to deny that religion, especially Christianity, has any role or had any role in the creation of Europe. When this issue arose in drafting the preamble to the European Constitution, George Weigel remarked that some in Europe seemed to believe that between Marcus Aurelius and Robespierre, nothing happened. This desire to sweep the public memory clean of religion, especially of Christianity, represents the kind of willful historical amnesia once associated with Stalinist Russia. It's proven convenient for European governments seeking to privatize religion and thereby to facilitate the emergence of a post-religious, post-modernist Europe. It's a striking irony that the primary roadblock to this project in Europe is not Christianity, at least not yet. The primary roadblock is European Islam. In the United States, this problem has its counterparts in a kind of Rawlsian strict separationism that ardently seeks the removal of most religion, and certainly traditional religious morality, from public life. I believe the privatization, strict separation view of the First Amendment is historically and constitutionally flawed. More to the point, attempts to privatize religion will not work in the lands of Islam. The public possibilities of religious freedom in full, however, are critical to its acceptance there. This vigorous understanding of religious freedom affords all religious individuals and communities an equal right to conduct private or semi-private activities normally protected in a functioning democracy. But religious freedom in full also accords equal access by religious actors and ideas to the legal, political, and economic institutions and political processes of a state. This means that they may, for example, form democratic political parties on the basis of religious teachings, purchase property, receive charitable donations, or establish and run charitable organizations on the basis of their religious beliefs. It means they may publicly articulate norms of justice and the common good and seek to influence and change laws and policies on the basis of their religious teachings. It means that all individuals can run for public office regardless of their faith, membership in a religious community, or holding of a religious office. In short, it is these norms, not those of privatization, that stand a chance of enticing otherwise illiberal religious actors into the democratic public square, accepting its limits as well as its benefits. Let me conclude by addressing very briefly how the projection of these norms might be accomplished in U.S. foreign policy. I would apply three broad principles, none of which I would add are currently operational. First, there must be agreement within the U.S. political and diplomatic establishments that these norms are transferable, universal, and practical. Second, they must consistently be applied by all elements of our foreign policy establishment, from the president down to the junior diplomat, and as part of our democracy and governance programs, our public diplomacy, and our counterterrorism strategies. Third, the message to other societies must be one of universality and self-interest. These norms may have been instituted first in the United States, but we did not invent them. They belong to you as well, and it is in your interests to adopt them. Should you do so, it will help you obtain what you want. This message, it seems to me, can be applied to all of the erstwhile democracies of the Muslim-majority world. To repeat, none of this will be easy, but it seems to me that the humanitarian and national security arguments are sufficiently strong that we should at least undertake the effort. Indeed, our future may depend upon it. Thank you.
Thank you very much. Let me begin. I'll ask a few questions, and then we'll open it up to the floor. Tom, let me begin with you, and I'd like to start the conversation between the different presentations. If you think about the remarks that Steve shared with us, and we think in your talk, it was a little unclear to me whether you would describe the commitment to religious freedom as being what Steve might think as a preferred outcome or a preferred strategy for getting to an agreed-upon outcome. And in your last remarks, you seem to imply that it was kind of we all agree on the end result. It's strategic. Let's assume for purposes of discussion that there is some disagreement on the outcome. What tools do we have available, and how effective are we likely to be using tools of persuasion, bargaining, and power?
Well, of course, it's a great question, Alan. I believe it's both an intended outcome as well as religious freedom norms playing into the strategy that we would adopt. I see it primarily as an act of persuasion, but in some cases, bargaining will be involved. I don't tend, though, to think in these terms, and I don't mean to dodge the question by saying it's all of the above. What I did not discuss in this talk was the severe deficiencies in American diplomacy in approaching this. I alluded to it. I'm trying to make the case that we should be doing things that we are not doing now. I did mention that we are required by law to advance religious freedom. There's a statutory mandate. But in fact, we're not doing it very well. There's a great deal of rhetorical reference to this by the President, by members of Congress, by the U.S. Commission on Religious Freedom, but we do not do the kinds of persuading and bargaining that I think Steve was alluding to, and that I would enjoin us to do. I would recommend that we develop strategies for every country, that every country is different, that we would use strategies keeping in mind an end product, which would be the establishment of norms of religious freedom that would look very different than our own First Amendment, whether the Establishment Clause or the Free Exercise Clause, but would contain basic red lines, some of which I mentioned there. So I'll stop there. It's a little bit of a dodge because I don't think in terms of bargaining and persuasion as methods, as Steve has outlined them. I do think in terms of describing what is our national interest. I believe this is in our national interest. It's going to look different in every country, but I believe in every country in which particularly religious extremism is being exported to our own shores, it's in our interest to figure out the proper strategy. I mean, that's what I really want to rest my argument on.
Thank you. Now I'll go to having asked a question that's social science-y and policy-based, I'll go to the other extreme. Trey, for you, I have a question that's actually fairly doctrinal. You seem to suggest that we're pretty much okay in terms of the way that we're applying our prescriptive jurisdiction principles, even when we're dealing with things like antitrust or securities litigation, we're essentially applying the effects doctrine. But I think it seems to me that one of the things that we're required under customary international law to take into account is the balancing between competing jurisdictional interests. Right? If you look at things like our application of export control laws to non-U.S. persons, if you look at the way we balanced or didn't balance competing interests of different jurisdictions in a case like Hartford Fire, right? I think there are serious questions about whether, at least in some prominent cases, we are in fact complying with customary international law with respect to the extraterritorial application of U.S. law. Are these anomalous cases, or am I misreading your claim that the problem, there's much ado or maybe not so much ado about nothing here?
Well, I think it's a great question, and I think that what we have to do is remember that there are pretty much three steps in any process of litigation. The first step is the jurisdictional step, which can be short-circuited through, based on the Supreme Court's decision in Sinachem, a forum non-conveniens analysis. And in that analysis itself, it should explicitly take account of the public and private interest factors that weigh in favor of the court potentially exercising jurisdiction. So the reasonableness inquiry that you're talking about in terms of the restatement of foreign relations law, in a way comes in at the jurisdiction stage, preliminary stage, through forum non-conveniens. I think the second question is the jurisdictional perhaps merits question of how we read the statute. And I think in that circumstance, the Supreme Court, if you read Morrison, I think has decided that they don't want to get into reasonableness inquiry, at least at this point. First and foremost, we want a clear statement of extraterritorial reach of a statute. And so if that, the answer to that question is no, then the case is over with, no need to engage in the reasonableness. So we have two steps in the process. One, in terms of jurisdiction and forum non, which necessarily takes account of reasonableness as part of an inquiry into other factors. Two, a question through Morrison in terms of extraterritoriality as applied by the Supreme Court, which doesn't take it into account at all. And then to the extent that the law is applied in an extraterritorial fashion, then I think you get the comity rationales which seem to animate Hartford Fire, which might come into play in terms of a discretionary abstention doctrine, which even though the court says this is the most convenient forum, and even though the court determines that the law is applicable extraterritorially, the court should still not exercise jurisdiction on the given facts. I think if you look at a lot of these cases, the ATS is a tough case for all of these reasons. One, some courts have found it's not susceptible to forum non because Congress seemed to explicitly grant a forum in the United States for this. And two, it's necessarily applying international law to foreign facts, which means how do you reconcile the comity interests? ATS cases may be different, but I think in sort of your run-of-the-mill cases that involve the extraterritorial application of U.S. law, there are various domestic doctrines which seem to take account of the international requirements for reasonableness.
John, I also had a question for you, also on a somewhat doctrinal issue. I was a little confused about the move to make the argument that there was no basis for civil jurisdiction when you look at jurisdictional principles. I mean, it seems to me that what international law regulates here is prescription, and it doesn't really stipulate what the form of prescription is. It's simply a matter of making the state's law applicable. And so I don't really understand why you make the move to say civil jurisdiction is excluded. I mean, my colleague Jenny Martinez, who has either been here already or will be here tomorrow, has talked about the role of things like forfeiture of vessels in the context of the slavery cases, so there's 19th century antecedents to that. Secondly, related, you talked about the use of the federal statute, the ATS, as representing the creation of federal law, but isn't that because we're in a particularly dualist system? I mean, isn't this really a matter of incorporation of international law, a particular means by which we choose on our domestic constitutional system to incorporate international law rather than the creation of U.S. law?
Well, I would say if international law provided a civil law remedy between individuals, that you could say yes. But what I'm specifically arguing is that the creation of an individual remedy for a violation of the law of nations, which is inherently applicable only between states, is necessarily an act of domestic lawmaking. It's a choice, and this gets kind of to your other question. It's a choice about how a state is going to implement its international legal obligations. That's why I say there's a substantial public interest component rather than just merely the transitory claim between private individuals about an injury that's been suffered. And so it's that aspect of things that makes if we extend our decision to create a civil remedy to a state that has made no such decision, then we're interfering with their implementation of international law. We're implicating their public interests. Now, that's not to say that if they've implemented it in a similar way that we can't apply the law of the place. I'm not saying that at all. I'm just saying that international law doesn't necessarily require, well, I should say, states have not universally provided for a civil remedy, so that remedy is not available in every state legal system. And if it's not available there, and if it's not available in international law, then I have trouble understanding how you can say that this is merely the incorporation of international law. It is the creation of and this is exactly what Scalia said in his dissent in Sosa. When we say that we can create a federal remedy, and even the majority referred to the remedy as a federal remedy, we're saying that we are allowing the creation of domestic law. And then the net result of that is, as I think Ernie Young has argued, that that's the retail incorporation of international law in some sense. Okay? but it's that creation of a federal remedy. And there are now, in the corporate liability context, lots of folks who are saying, hey, look, corporate liability isn't really an issue of international law, it's an issue of domestic law. And that's another example of how bound up the domestic law question is in the nature of the remedy, including against whom it may be.
And has left the room. She would disagree with that, but you know her position on this. Steve, I have a question for you, and maybe it's a continuation of a discussion that we've had off and on over the years. You know, there's an interest-based focus on what norms states are trying to project, and what tools are going to use to try to achieve that. In your presentation, bargaining, persuasion, and power. How would you analyze, Steve, say the projection of human rights norms, U.S. constitutional kinds of principles, civil rights, Bill of Rights types of norms after World War II, which then get reflected in the Universal Declaration and spread? I mean, there's not, in some ways, you know, the United States is not bargaining with countries. We're not sort of sanctioning them. Right? It's a more normative spread, right? So ideas and norms seem to matter. Now, I know you adverted to John Mayer's work, which seems to come from that tradition, or seems to reflect that tradition, but is that a different way of thinking about these problems?
No, so I think the question here is how, if you take that productive power box, which I think is the most difficult one to grasp. You know, I think so what do you get in Mayer's work? You get this notion that you have sets of norms developed essentially in the more powerful states, the advanced industrialized states in the contemporary environment. These norms get embodied in international organizations. These international organizations, public and private, often become the vehicles for supporting these norms in other countries. So that's the argument. Now, here's the question. How, and this is something, I don't know what the answer to this is. The norms can be formally accepted and have very little impact on people's behavior. So, I mean, also, and this is in the sociological literature, and Mayer's work, and actually the work of other people that have looked at these kinds of phenomena, they talk about decoupling. So people say one thing, but they do another, and they don't actually ever resolve the contradiction. And look, for me in the contemporary world, the most interesting example here is looking at the Arab Spring. So all those people in Tahrir Square who were interviewed on CNN could have been, you know, we could have pulled people off the law quad here and heard exactly the same language. And the question is, and this is genuinely a question, I don't know what the answer is, how consequential is it? And how deep did the actual beliefs go? Now, it may not be consequential because these people are a small part of the population, they can't get themselves organized, forget about that. But how much of these beliefs actually, you know, are they things which you say to a Western reporter in English? And when you're actually confronted with the question of whether you want to have genuine religious freedom, for instance, would it just go by the by? I don't have a good grasp of that. You know, the argument that I find in the political science literature that's most persuasive is an argument that Keck and Sickink made in their 1999 book, which is that if you want to spread these international norms, you better have some local actor who wants to buy into them. And the two examples I give in the book, I mean, one is foot binding in China, in which that is a very successful campaign by Protestant missionaries to end foot binding. Why is it successful? Because there are a lot of Chinese nationalists who want to be modernizers. So they're willing to go along with this. You have a similar campaign, again by Christian missionaries in East Africa in the 1920s, to end female genital mutilation, and it totally fails because they're not able to find domestic allies who are willing to buy into this particular norm. So I think this argument about productive power can actually really be consequential, but somehow it's got to not just come from the outside, but also slot into what's happening domestically. And if I'm in total agreement with Tom's analysis of where we'd like to go, but the fact that you have less religious freedom now than you've had in the past, despite the fact that we've had this norm of religious freedom floating out there for decades, is an indication of the fact that the existence of the norm doesn't mean it's going to actually be, and even people saying it, doesn't mean it's going to be embodied in the actual practice of states.
I have many more questions, but I want to make sure that you have a chance to ask your questions or comments. So if you have something that you'd like to raise with the panel, please approach the microphone. I think the custom is that you identify yourself. If you have a particular panelist that you'd like to address your question to, please so state. We are getting near the end of the day, so I guess ideally it's better if it's a question rather than a paragraph with upward inflection at the end, or a paragraph followed by "Don't you agree?" So, are there questions for the panel? Young man in the front row.
So I'd be curious to know whether some of you could comment. Some of the presentations were so different, and I'd like to know whether there's any wisdom, say, for, Tom has a very clear normative project. Is there any wisdom to be imparted for him from the point of view of those of you who've been toiling in these other vineyards? Or are these just sort of four separate presentations that don't touch each other?
No, they're not four separate presentations. Well, I mean, we've already heard some of the conversation between Steve and Tom. Is there a role for legal norms in this respect? Could we use litigation? Could we see a violation of religious freedom, civil ICCPR norms be litigated in U.S. courts as a way of trying to advance this agenda?
Yeah, I mean, I think that would be my question. There's two ways. One is the diplomatic way of encouraging religious freedom, which I take your presentation to be discussing, which I think is very interesting, appropriate, and robust. And I think what is nice about it, and what connects it up to some of the things that Steve said, is that it's about persuasion. I mean, it's not about whole, transplantation of U.S. legal norms through constitution drafting, as we saw after World War II in Germany and Japan, or wholesale incorporation of U.S. First Amendment legal norms, which gives the opportunity for the domestic state to come to some conclusions as to the met and bounds of its rights. For instance, in the context of freedom of speech in Germany, robust freedom of speech, but quite different. They allow the outlawing, for instance, of the Nazi Party based on historical realities and notions of human dignity, which we have rejected in the United States in favor of a more libertarian construct, especially when it comes to political speech. I guess I would have that same question that Alan just posed, which is, besides the diplomatic approach of persuasion, is there a role in U.S. courts when it comes to encouraging, in some ways the same question, is there a role for U.S. courts to encourage this, either by allowing suit or encouraging suit? I'm trying to think of the statute under which it would necessarily be brought. I'm not even sure many robust ATS claims would even allow one, maybe for religious persecution. And in some ways we do. It's called asylum, right? We allow people to seek asylum when there's religious persecution. But I wonder if there is any role for U.S. domestic law as opposed to just U.S. diplomacy.
Well, it's a great point. One of the motivating forces in the passage of the 1998 International Religious Freedom Act was the perception that asylees, or those seeking asylum in the United States, and refugees seeking resettlement from a third country or a second country to the United States were being discriminated against by U.S. immigration officials and by the UN High Commissioner for Refugees if they were religious asylees. And I distinctly remember one case where a whole family of people who alleged that they had converted to Christianity in Iran from Islam and had fled to Turkey were interviewed by UN officials. They said that they had been converted to Christianity by hearing an uncle translate the Bible from English into Farsi for them, and they had become Pentecostals. And so the questions put to them by the immigration officials were questions like, can you explain to me what the synoptic gospels are? And on the basis of their befuddlement at such questions, it was decided that they weren't Christians at all, and they were about to be sent back. All this by way of saying, and that's the end of that story is a good one. We were able to intervene. I'm a little bit skeptical certainly of the international courts. The question of whether U.S. courts can play an equitable role here is, I don't know. I haven't thought about it. my instinct is to say, keep the courts out of it. I will say one other thing, though. When I talk about democracy and governance programs as promoting religious freedom, one example that cuts across what we're talking about here is programs to develop litigators in China, defense attorneys in China, who can use the existing system of law in China to defend religious prisoners and others. We've had the Beckett Fund, for example, in Washington has tried this, but it's very difficult to sustain it. I think it's a terrific idea, and it's precisely the kind of example I would give of something that it really isn't. I'm not sure if you would put it under persuasion or bargaining, but it is, and certainly China is nowhere near adopting religious freedom, but it is a baby step that I think could play to their own understanding of their own self-interest, which is rule of law.
I'll have one afterwards.
Thank you. So I think any discussion of extraterritorial application of U.S. norms would be incomplete without thinking for a second about the Maritime Drug Law Enforcement Act and similar statutes. So John Marshall, in his Robbins speech, was talking about things that we could never do under U.S. law. He said it would be crazy to have a law that would deal with gambling on a British ship, or British slapping, a British merchantman sailor slapping his officer on board a British ship. So it turns out we have this law now, which has steadily expanded and now actually criminalizes drug trafficking, not just on the high seas, but purely within foreign territory with no U.S. nexus. So originally it applied on the high seas, and there have been cases when vessels have been arrested in foreign national waters, not the high seas, and the crews are brought back to the United States, where they have never been and may never have been going, and are put in jail for a very long time. And now there are and this idea seems to have legs. It has been expanded not just to drug trafficking per se, but the use of various submersible vessels anywhere in the world, even in foreign waters. That's quite remarkable. I think it's unconstitutional. It seems to go far beyond what international law would allow for universal jurisdiction. The problem isn't so much an international legal one, because let's say that the home countries of these people consent or don't care or get paid or don't even know, as sometimes seems to be the case. They ask permission, but in some of these cases it seems quite clear that they've actually asked permission from the wrong country, not being clear where the person comes from. So it seems, so the question is this. So we have this thing. It's a little bit weird, I think, and it seems something that conservatives who do not like the use of universal jurisdiction under the Alien Tort Statute should be really upset about this, because there's no serious argument that drug trafficking is a universal jurisdiction crime. And you'd think that liberals who don't like American normative imperialism would also not like this, because this is a particular American thing, that drugs are like the worst thing, and if we're ever going to use universal jurisdiction for something, it won't be war crimes, it'll be drugs. So at the same time, there's actually no serious opposition to this. It goes largely unnoted. Clearly more people are in jail for this now than have ever been in Guantanamo, I think even at the peak. And it goes under the radar, even though, and it's a serious assertion of extraterritorial authority. One might add to this list, though no one seems to be in jail for it, the material support statute, which also would make, if a Colombian farmer supports his local FARC, they would be prosecutable in America, though it has not been used. So why does this happen? Why does it go down so easy? And then similarly, why do so many more apparently trivial or marginal assertions of extraterritorial powers get so much more controversy?
I think it's because we necessarily, in our constitutional system, require the public to care, right? If the Military Commissions Act unlawfully asserts domestic criminal violation of the law of war against an alien, enemy combatant, nobody in the U.S. public cares. That the international community might care, but the U.S. public doesn't care. And that's back to my earlier point that Congress possesses the constitutional power to violate principles of international law. Congress's choices in that area are dictated by local politics, right? So if Congress is passing policies that are suspect under international law, who's going to, and it involves people about whom nobody in the polity cares about, who's going to object?
Foreign commerce? Foreign commerce?
Right.
So there's no nexus to the United
So it's your view that the define and punish power has to be exercised consistently with the law of nations? Because if all Congress could do under Article 1, Section 8 is punish violations of the law of nations, I would agree with you. But Congress has the power to define and punish violations of the law of nations. Now, arguably, this was done so that they could superimpose a federal view of the law of nations on states who had contrary views. But in this case, it's being used to extend a uniquely U.S., idiosyncratic U.S. view, potentially, of the law of nations. I don't know that Congress believes that international drug trafficking is a violation of the law of nations. But at least arguably, if that's the basis, one could make the argument, right?
I mean, the other thing that strikes me is don't you have a Fifth Amendment issue? Because the lack of a U.S. nexus, I mean, depriving an individual of life or liberty without due process of law without any U.S. nexus. Now, of course, the problem with that is whether or not the Fifth Amendment applies abroad, which I think will be a question we take up in a panel tomorrow on whether or not the Constitution applies abroad. But it seems to me you have a Fifth Amendment issue there as well. And I think this also arises, besides the statutes that you mentioned, I think isn't there like a child trafficking statute that's now in the books, like a Protect Act for Children? Right, and so it raises similar issues, and I think there have been some cases both challenging it under for jurisdictional reasons, and the rationale has been foreign commerce and then Fifth Amendment, but I don't know the results on the Fifth Amendment. Well, what's interesting about that analysis is how radically different it is from the Fifth Amendment analysis or the 14th Amendment analysis in the civil context, which requires a significant contact or aggregation of contacts with the forum state. So there's an implicit nexus requirement as part of civil Fifth Amendment, 14th Amendment due process analysis, which it's striking that there is no similar requirement in the criminal context.
I promised Eugene that he would not have the last question, so I'll ask the last one and then we'll break. I'm here in my capacity as a lawyer, but of course I spent 11 years before coming to Stanford in the State Department, and in some ways it's the foreign policy issues that I still have the most fondness for. And Tom, when you talked about the promotion of religious freedom, you identified the limits of prudence in terms of our ability to advance that agenda in particular states. One of the things that I have been troubled by is trying to figure out how do we balance the interest of religious freedom against other competing national interests. And so, for instance, this seemed to me to be a problematic issue when we were trying to deal with North Korea on the nuclear issue, and the wagon was pretty freighted as it was in trying to get the North Koreans to make some movement on the nuclear issue, and then we added onto that our complaints or concerns about the religious freedom issue. Now, who knows how things would have come out. It turns out the North Koreans are pretty good at cheating in any case, right? But would we be better off having subordinated the interest in promoting religious freedom in that context in the interest of the issue of trying to address the nuclear crisis? And what currency do we assign to the competing interests?
I think the answer is no, that we would not have, it wouldn't have come out any differently had we not included religious freedom for North Koreans, simply because the North Koreans, in my view, are pretty close to being irrational actors. It's very difficult to predict what they're going to do except to protect their own interests in a potentially in a violent way. I mean, this is the rogue state of all rogue states today. So it may not be the best example to make the point that I think you're trying to make, and that is that occasionally we don't want to, when we really have something that is more important, we don't want to advance religious freedom. And in theory, I would agree with that. There may be a better example. I'm not going to try to find one for you and do your work for you. But I will say this, the problem is not that we have allowed religious freedom to swamp other national security issues. Precisely the opposite is true. We speak about religious freedom, we pretend to implement a law, and we pretend to sanction countries. We've been 13 years with a law that says we're going to sanction countries, and we haven't sanctioned any country in the world for religious freedom except poor old Eritrea. And it made matters worse, which simply proves sanctions don't work, as far as I'm concerned, unilateral sanctions. But the answer to your question, in my view, is that religious freedom isn't everything, but it's not nothing. And it's been treated pretty much as nothing, despite the fact that somebody, obviously, in our bilateral talks with North Korea, raised the issue of religious persecution. It's a terrible problem, as I'm sure you agree, in that country. I mean, religious people of all stripes are crushed, literally, in North Korea. But raising the issue with the North Koreans does not approximate beginning to solve the problem. Only in the State Department would that phrase, which you hear over and over again, be confused with solving the problem.
Yeah, all right. I think we've come to the end of our appointed time, so my final task is to ask you simply to join me in thanking our panelists for their really thoughtful presentations.